Good afternoon. Many of you will remember, or may remember, that wonderful Master of the Rolls, Sir George Jessel, who it was said never actually reserved judgment. And his famous dictum, "I may be wrong, I sometimes am, but I am never in doubt, except upon the construction of a written document." And that's our topic for today. What are the basic principles which we must apply in construing a commercial contract? Well, this is something as lawyers we're doing every day of the week. People come with a document, a contract. It may have been artificially drawn. It may have been drawn by the most expert solicitors. It may have been the subject of no negotiation. It may have been the subject of months of negotiation. But in any event, we've got various rules or precepts we can apply with a view to determining what the meaning is, which is ultimately what the court will be asked to do. And the first point to remember, though it's the most obvious one, I suppose, from Contracts 1, is that when we're looking at the rights and liabilities of the parties, we need to determine the meaning objectively. And we need to look by reference to its text, context, that's the entire text of the contract, and the purpose of the particular contract. And these various matters have been discussed in some detail by a powerful Court of Appeal in Western Australia, always good cases from Western Australia, in a case called JKC Australia, LNG, which has got something to do with gas, I think, and CH2M Hill Companies number 2, which you'll find at 2020 WASCA 112, and it's a judgment of their Honours Justices Buss and Vaughan. Now, when we're looking at the meaning, in order to determine the meaning, their Honours tell us that when we're looking at the meaning, we need to ask what a reasonable business person would have understood the terms to mean. So, when we're looking at it objectively, what would a reasonable business person think the contract meant? And we need to then look at the language which the parties have used, the circumstances addressed by the contract, and the commercial purposes or objects to be secured by the contract. So you've got those three things to bear in mind when attempting to divine or winkle out the meaning. And when we're looking at a commercial contract in particular, we adopt an approach which endeavours naturally to make commercial sense. We've got to produce a commercial result. And that means that you've got to place a meaning, if you can, on the terms of the agreement which produce a commercial object or the commercial result of the agreement. And that, of course, means that you should avoid construing it so as to bring about a commercial nonsense or some result which might be commercially inconvenient. So, men of commerce, of course, they want some result. There must be a bit of an inference there, but they're not going to be contracting over time to do something if they don't want some commercial result to flow from it, which, with an invisible hand operating, presumably means some benefit for both of them. Now, when we look at it, remember, of course, we've got the usual rule concerning extrinsic evidence. And their Honours tell us, I'm looking at paragraph 67 in their long judgment, that ordinarily the process of construction is possible by reference to the contract alone. So, usually you're confined within the four walls of a document, and often there'll be clauses in the document, we've all seen them in the boilerplate, which will preclude reliance or indeed any reference to any statements made either prior to the contract being negotiated, etc., etc., etc. So unless it's within the contract itself, nothing flows from it, which is, I suppose, why you've got to be particularly careful in relation to pre-contractual negotiations. Doesn't always work, of course, without getting too much on the side wind. Sometimes misleading statements made in the negotiating of the contract might have an effect outside the contract, of course, because they've induced you to enter into the contract. And if you're in that position, then any sort of clause attempting to exclude those clauses or reference to them or statements will be difficult. That'll be a difficult thing to rely on. Now, that's a story for another day. We'll look at that. Nevertheless, even if we've got a document which squarely sets out all the terms and conditions, as their Honours tell us, there may be sometimes a necessity for recourse to external events. So it may be necessary to look at some background facts to perhaps identify the commercial purpose or objects of the contract, to look at the genesis of a transaction and the background and the context of the market in which the parties are operating. Or it may be necessary, if you've got a problem of construction, to determine whether or not there's any ambiguity itself in the contract. So you can't you can't look at a contract selectively, as it were. You've got to read the whole thing through, naturally, from start to finish. And you're really looking, naturally again, for a harmonious construction. You want to try and work out how each of the parts interplays with the other, all the others. And in that sort of situation, you really should be trying to give each clause, each separate clause, some meaning and some effect. Because as in all documents, there's a presumption against surplusage. You're not going to put in something that's extraneous. Every clause presumably has got some sort of meaning and effect. And as the Honours tell us, that when you're construing it, preference is given to a construction which supplies a congruent operation to the various components of the contract as a whole. Nice expression, isn't it? A congruent operation. If only all of life were like that. Now, when you're looking at the commercial purposes or objects, then you can look at you can look at express or implied terms, an instrument, and also admissible evidence, whatever that may be, in terms of the surrounding circumstances. And sometimes, as they say, it'll be apparent from the contract as a whole. And if it can be readily ascertainable objectively to a reasonable observer, then that's what the courts would conclude was the purpose and the object. And so you can't look at any thought of making some sort of desirable result. You've got to look at the actual terms. You can't just look at what you think the result should be. But it may be that, as I've already said, in terms of extrinsic evidence, that may help you get the contractual context, which may be very relevant. And as I've already said, as they tell us at paragraph 70, when you look at it, you should not construe anything which is going to result in a commercial nonsense. And of course that leads to a problem sometimes because no doubt when you're negotiating, as I always say to my classes, it may well be that there's some deal breaker in there which neither party wishes to address directly. So you're close to being ad idem, the famous consensus ad idem, but you know if you raise X, whatever X may be, then the other people, oh no. So both parties, to keep the deal alive, are prepared to let the matter go through to the keeper, in cricketing parlance, in the hope that everything is going to work itself out. And of course it's when it doesn't that you then have the usual problem of construction. You may have something where there's a deliberate ambiguity. That's not often addressed in the legal literature, but it's out there all the time, I think, in a business context. So the court tells us that if you've got two possible constructions, then obviously what you've got to look for is something that avoids capricious, unreasonable, inconvenient or unjust results, even though the construction is not the most obvious or the most grammatically accurate. And once again, the drafting itself may give some sort of indication in relation to that. So if you're looking at a constructional choice, you need to consider what a reasonable business person reading the relevant clause or agreement would understand it to mean. And it's from that perspective that you then need to explore the document. And of course, you need to look at the contractual expectations and, I guess, as I said, the notion that pacta sunt servanda. That's to say in Latin that contracts are there to be observed. And for that purpose, you shouldn't adopt a narrow or pedantic approach. Well, all interesting, and this is a very up-to-date discussion of the basic principles. There are lots and lots of cases out there, of course, all the time. And this was a case looking at the construction of documents in the terms of a performance bond, which brings with it all sorts of complexities as well, because performance bonds and first demand guarantees are normally construed strictly. ANCAR and other cases in the High Court tell us that. Strictissimi juris, I think, is the Latin expression we use. Anyway, that's a subject for another day, but have a good look at JKC. It's a very up-to-date reference, as I try to be. It's a couple of weeks ago, and it's a very detailed discussion in the context, and it's well worth having a look. Well, I hope you're all keeping safe and well. It's troubled times, and obviously we're still in the grip of this terrible virus, but all keep safe, and I'll talk again to you shortly, I hope.